Good morning. Good morning, my friends. Thank you so much for coming to hang out with me today on this Tuesday, August 27th. We're still in a holding pattern on the Robert Telley's verdict, which is crazy because they were out for more than 4 hours yesterday. And what else happened yesterday? Well, you guys know. Paul O'Keefe, Peggy O'Keefe, Mr. O'Keefe Sr., and Kaylee, the niece, filed a lawsuit, civil lawsuit against Karen Reed. CF McCarthy's in the Waterfall Grill. Waterfall Bar and Grill. And I had wondered for a long time, and I've asked you guys this for a long time, was a lawsuit ever filed with regard to the car accident? We didn't have an answer. And now we do, because they just filed it yesterday, which is great, incredible, interesting timing. We'll talk about that. We'll talk about the merits of this lawsuit and whether or not I think it will be successful. We're going to talk about all of the advantages that Karen Reed will have in this lawsuit and how it's going to help her criminal case. And we are going to talk about why I think it was not a very good idea to file this lawsuit right now. Because the floodgates are going to open. We're going to talk about that. Mandy, thanks for becoming a new member. And on top, thank you so much for becoming, for being so awesome and for giving super stickers every single time you come in. Right. What if there is no accident report? I have the full copy, Cherie. Thank you. But I had it already from the court. So thank you so much for that. It is a 21-page. It's a 21-page complaint. It'll get stayed, maybe. Pending the outcome of the criminal case? Maybe, maybe not. Statute's not up until January. Statute's not up until January 29th of 2025. They should have waited until January 28th of 25 to file this lawsuit, but they didn't. They're doing it now. And all this is going to do is going to open up a whole bunch of more discovery. So we're going to see. Wheels of justice turn very, very, very slowly. This is not a case that will ever come to trial before the criminal case does. But there are a lot of advantages. So yay. Thank you, Hope. Thank you for getting so excited when you see the notification. I love that. Adam Lally's resignation. I love when you guys change your names. It says Paul's running out of money and needs cash to sit in for the next trial. There's only two reasons that people file civil lawsuits: money and revenge. Right? Because we can't turn back the clock and undo the murder of Officer John O'Keefe. The only thing a civil lawsuit isn't designed to do is get you money. Or in some people's minds, it's just a way to get revenge. Which one do you think is going on here? If not both. Susan, thank you so much for your $50 super sticker. I appreciate you and love you oh so very much. We're going to get into that in a minute. We're going to let some people have some time to come in here. Tell me what you guys think about all of this. But while we're waiting and before we do that, let's hear a word from our sponsor, because we have a sponsor and our sponsor is amazing. And this is a really big deal. If you guys don't know about it, if you haven't already seen my spot on this, there was a giant hack last week. Many of you have heard about this already. Some of you have not. Where a company has leaked every single American's social security number to the dark web. And if you have ever had your identity stolen, or if you have ever known anyone who has had their identity stolen, it is an absolute nightmare that can take years and years to undo the damage that can be done in a very short period of time. Aura is my sponsor. I use Aura, and I'm very lucky that I do, because yesterday I got a notification from Aura that they found my social security number on the dark web. And so they told me what to do immediately, and I'm going to do it and take care of it. But I have heard so many horror stories from you, my viewers, and from other people who have told me things that have happened to them because of identity theft, including the titles to their houses being taken, credit being opened under their name, and then their credit is trashed, and they go to apply for student loans for their kids who are going to college this year, and all of a sudden they're rejected and they can't figure out why. And it's because somebody had stolen their identity and opened credit cards in their name and defaulted on them. So this is really scary. Please listen, because my sponsor, Aura, can help you. And with a free 2-week trial, you can find out if your social security number has been leaked to the dark web like every other American. So take a listen. Today's video is sponsored by Aura, and it's a really important time to be talking about them because hackers may have stolen the social security numbers of every American. Over 2.9 billion records were stolen from National Public Data, which offers personal information to employers, private investigators, staffing agencies, and others doing background checks. These stolen records include a person's full name, address, date of birth, social security number, and phone number, along with alternate names and birth date. And members of this hacker group have reportedly released this information on the dark web for free. I don't know if you've ever had your identity stolen, but I've had clients who've had their identity stolen. And not only is it a major hassle, but oftentimes before you find out, it's too late. The damage can take years to undo, and it's a hassle that you definitely do not want to deal with. So if you haven't been taking precautions before with your personal information online, this should be a huge wake-up call. You've never been more vulnerable online than you are right now. But I'm not too worried about it because I use Aura. Aura alerts me if they find my phone number, my email, my social security number, or any other personal information on the dark web. They're going to let me know fast if anyone tries to use this information to access my credit or bank accounts. They give me up to $5 million in identity theft insurance should the worst case scenario happen. They also provide a bunch of other features to keep you safe online, all inside one app. And you can go to my link at www.aura.com/Melanie Little to try it for free for 14 days. That'll be enough time for Aura to find out if any of your personal information or data has been exposed. I highly recommend you do this right now because not only is National Public Data not going to do anything to help you, they probably aren't even going to face any repercussions for this breach. I'm not leaving myself and my family vulnerable to data breaches. And if you don't want to either, you want to go to my link, www.aura.com/Melanie Little, to try 2 weeks for free. You can thank me later. You can thank me later because they told me that my social security number is out there, and I'm so glad that they did because now I can take the steps to prevent it. Let us take a look at the civil lawsuit that's been filed in Plymouth County. By the way, I have a call into one of my friends who is Massachusetts personal injury lawyer. I'm waiting back for a call from him because I want to find out if Plymouth County is a more friendly venue for plaintiffs than Norfolk County, because all of the other plaintiffs in this case live in Norfolk County. Paul O'Keefe is the only one that lives in Plymouth. So I'm curious about that. If anybody in the chat knows, if you can chime in on that, because a lot of times, for example, in New York, as a plaintiff's attorney, if you can, you always want to get into the Bronx. If there's any way to get into the Bronx as a plaintiff, you want to get into the Bronx because Bronx juries are traditionally very generous. A broken fingernail, is worth like $1 million. And Suffolk Westchester County juries actually are known to be the most stingy when giving out awards. So I'm wondering if Plymouth County is a more friendly county to plaintiffs. If anybody knows, you can let me know, because that choice of venue is always an important thing. I need to pull something else up here. Or yeah. The jury on Telus is supposed to come back at 9 a.m. Pacific, which is noon Eastern. So we have plenty of time for this. Plenty of time. And here we go. Everyone and their mother was covering this yesterday, so you probably have already seen the lawsuit. I'm not going to read it entirely to you, every single paragraph, because many of them are repetitive. but I'm going to explain to you what it's about and whether or not I think it's going to be successful. Because this is my wheelhouse. This is what I do. And here we go. This is interesting. Somebody says here, my experience in Plymouth is that they're kind of stingy. That's interesting. His lawyer Diller has a video on YouTube that explains his origin story. I saw that, but I didn't get a chance to read it. I did not get a chance to read it. So that is interesting. Okay, this is a little bit better for you. And here we go. This is filed in Plymouth County. It was filed yesterday, August 26th of 2024. Why do you think that is? Well, if they had had a conviction on the criminal case, this lawsuit would have been filed right away because it would have been easier to prove. They were waiting for the decision, in my opinion, on the juror question to decide whether or not to file this. That decision, as you know, came in on Friday, which was just outright denied by Judge Cannoni without any sort of interview or interviews of the jurors, without calling them back in to poll them or to just even simply ask them whether or not they acquitted on counts 1 and 3. And since that decision came in on Friday, for some reason, they decided to file it yesterday, which was the 26th. The wrongful death statute of limitations in Massachusetts is 3 years, which is unusual because in New York, it's 2 years from date of death. I think that's a long statute for wrongful death in Massachusetts, but maybe one of the only friendly laws, I guess, if you're a plaintiff in Massachusetts. So they technically had until January 28th of 2025 to file this lawsuit, but they've chosen to file it now. They've chosen to drag Kaylee, the niece, into it. And they've also chosen to file on behalf of John's dad, John O'Keefe II, who was not even at the trial, at Karen Reed's trial, for much of it. And I'm not sure about his health. I'm not sure the reason why he wasn't there, but we noticed that he wasn't there. And so I find that interesting. Does he know that he's a plaintiff in this lawsuit? Like, that's just, Yeah, somebody said that, right? Wonder if John's dad even knows about this lawsuit. Well, here it is. It's Paul O'Keefe as personal representative of the estate of John O'Keefe, John Joseph O'Keefe III. Paul O'Keefe individually, John O'Keefe II, Margaret O'Keefe, and Margaret O'Keefe as grandparent / guardian of Kaylee. Those are the plaintiffs. Again, CNC Hospitality, DBA, I'm doing business as is what that means. CF McCarthy's. GNS Hospitality, LLC, DBA, CF McCarthy's. Waterfall Bar and Grill, Limited, DBA, Waterfall Bar and Grill, and Karen Reed, defendants. Parties and jurisdiction. I'm going to have to enlarge this on my screen, so I'm not going to be able to look at the chat right now. So if you're chatting and you want me to see it, I'm not going to be able to see it right now. The plaintiff, Paul O'Keefe, Paul, is the surviving brother of the late John J. O'Keefe III, JJ, John, or decedent. But you're going to see that they refer to him as JJ throughout this complaint. And is the duly appointed personal representative of the estate of John Joseph O'Keefe III, who died on or about January 29th of 2022. At all relevant times, material here too, the decedent resided in Canton, Norfolk County, Massachusetts. At all relevant times, material here too, the plaintiff, Paul, resided in West Bridgewater, Plymouth County, Massachusetts. The plaintiff, John O'Keefe II, John II, that is John's father and Paul's father, is the surviving father of JJ and Kristen. At all relevant times, material here too, the plaintiff, John II, resided at 1 Meadows Avenue, Canton, Norfolk County, Massachusetts. Three, the plaintiff, Margaret O'Keefe, Margaret, who you may know or have heard of as Peggy, is the surviving mother of JJ and Kristen. At all relevant times, material here too. The plaintiff, Margaret, resided at 1 Meadows Avenue, Canton, Norfolk County, Massachusetts. The plaintiff, Kaylee, I redacted her last name, is the surviving niece of the late John J. O'Keefe III. At all times, relevant material here too. The plaintiff, Kaylee, was under the guardianship of John and resided in Canton, Norfolk County, Mass. 5, at all relevant times, the defendant, CNC Hospitality, LLC, DBA CF McCarthy's, is an independently owned restaurant with a usual place of business at 614 Washington Street, Canton, Norfolk County, Massachusetts. CF McCarthy's. CF McCarthy's had a resident agent, Stephen Carey. I redacted his address, Quincy, Norfolk County, Massachusetts. CF McCarthy's presently appears to be operated by GNS Hospitality, whose date of organization was 4/24/23. GNS Hospitality, LLC, DBA CF McCarthy, says the same location of business, same resident agent as CNC Hospitality, LLC. Any averments referencing or counts against CF McCarthy should be assumed to incorporate either or both entities listed here. 6, the defendant, Waterfall Bar and Grill Ltd, DBA Waterfall Bar and Grill, is a domestic corporation with a usual place of business at 643 Washington Street, Canton, Norfolk County, Massachusetts. Waterfall. Waterfall has a registered agent, Gerard Meehan, located at, I've redacted his address, Canton, Norfolk County, Massachusetts. All right, breaking from the document for a second. Wasn't Bridget Meehan on the witness list for the prosecution? And she was never called, correct? Isn't she perhaps co-owner and maybe wife of Gerard Meehan? And weren't they friends with the players in this lawsuit? Such as maybe not the O'Keefes, but the Alberts, the McCabe's. Weren't they friendly with the Meehans? Why aren't they suing Chris Albert's pizza place? Because that has nothing to do with this case. Why would they? Thank you, SC Shan. This is a case for personal injuries and wrongful death resulting from the alleged car accident that they allege Karen Reed was driving drunk and hit and killed John O'Keefe. So therefore, they're suing the 2 bars that allegedly overserved her and her. So I'm not sure why Chris Albert's pizza place would be involved here. They're just not a proper party to the action. But thank you for the super chat. And thank you, Kristen, for becoming a new member. Appreciate you. Look at Sarah in Schwackenhora gifting 10 memberships. Thank you, Sarah. Thank you, Sarah. You're so generous always to this channel. And, we're all in shock and horror. I thank to you the 10 of you who received those memberships. Welcome, welcome, welcome. The defendant, Karen Reed, is an individual residing at, and I redacted it, Mansfield, Bristol County, Massachusetts. So here's how choice of venue works. You can choose to sue in the county where any of the plaintiffs reside or where the defendants reside. They could have sued in Norfolk County, Bristol County, or Plymouth County. They chose Plymouth, and I'm curious about that. The judge who is currently assigned to this is a judge, I believe his name is Judge White in Plymouth County. There's only, I think, 5 judges that sit in Plymouth County. Only 3 of them are civil court judges. I don't know if anybody knows anything about Judge White, but let me know if you do. Facts. Plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety all prior paragraphs of the complaint. 9, the decedent JJ This is kind of cringe to me. Couldn't they call him Officer O'Keefe? If they want to distinguish him from the other John O'Keefe, the other plaintiff who's his dad, can't they call him Officer O'Keefe? But I don't know. The decedent JJ was the middle of 3 children in a tight-knit family. JJ was a third-generation Boston police officer. After the tragic death of JJ's sister Kristen and brother-in-law Steve, JJ took custody/guardianship of his niece Kaylee and nephew Patrick, who were 6 and 3 respectively. Over the next 8 years until his tragic passing, JJ raised and supported his niece and nephew. 10. After the tragic death of JJ, Margaret took guardianship/custody of her grandchildren, Kaylee and Patrick. 11. At all relevant times on or before January 29th of 2022, JJ and defendant Reed were in a dating relationship. 12. In the months, weeks, and days leading up to January 29th of 2022, JJ and defendant Reed's relationship was deteriorating. During such time, defendant Reed picked fights, experienced jealousy, and had delusions of unfaithfulness. Okay, remember, they're going to need to prove everything that they're alleging in this lawsuit. Who are they going to be able to call to take a deposition of to prove that? Just think of the subpoenas that are going to go out for depositions in this case. Every single person who's a friend currently of Peggy and Paul O'Keefe. All of the Alberts, all of the McCabes. On or about January 28th of 2022, defendant Reed knew that her relationship with JJ had run its course. 14. On January 28th of 2022, at or about 8:51 p.m., plaintiff arrived at C.F. McCarthy's. 15. C.F. McCarthy's was licensed to distribute, sell, or serve alcohol. 16. On January 28th of 2022, at or about 8:58 p.m., C.F. McCarthy's served Reed an alcoholic beverage. Reed consumed said drink. 17. On January 28th, 2022, C.F. McCarthy's, through its agents, servants, or employees, served alcoholic beverages to defendant Reed at or about 9:13 p.m., 9:20 p.m., 9:33 p.m., 9:57 p.m., 10:22 p.m., and 10:29 p.m. Reed consumed such drinks. They're pulling this straight out of the criminal case. And in my opinion, none of that has been proven. There's no receipt for that. The only receipt we saw admitted at the criminal trial was a receipt from the Waterfall, which had, I think, 2 Tito's and a Coors Light. So Yuri's math teacher, if you're in here, here's Yuri's math teacher. And that's why, hold on. Yes, me, myself, but I'm going to explain to you why that's, me, myself said yes, but the bar from proving it is much lower in civil court than criminal. It is, but then again, you still have to prove it. Yuri's math teacher, it's a fool's errand sponsored by the biggest fool of all time. Yuri's math teacher has the name Yuri's math teacher because of when Yuri was on the stand, he was counting these drinks and there were 2 Tito's on the bill, but they're saying she had 9 drinks. So there's the math. Number 18, C.F. McCarthy's, through its agents, servants, or employees, served defendant Reed 7 alcoholic drinks between 8:58 p.m. and 10:29 p.m. on January 28th of 2022. During all relevant times at or before 10:29 p.m. on January 28th of 2022, defendant Reed showed signs of intoxication while at C.F. McCarthy's. You and I both know there's been no evidence of that. No witnesses, no video that she was visibly intoxicated. In fact, every single person who gave a witness statement on the morning of or shortly thereafter, whenever they were interviewed, every single person, including Jennifer McCabe, including Brian Albert, said that she did not seem to be intoxicated. On January 28th, 2022, at or about 10:40 p.m., JJ and defendant Reed left C.F. McCarthy's. 21. On January 28th, 2022, at or about 10:40 p.m., defendant Reed was allowed to carry her alcoholic drink out of C.F. McCarthy's. 22, on January 28th, 2022, at or about 10:54 p.m., JJ and defendant Reed entered Waterfall together. 23, at all relevant times, Waterfall was licensed to distribute, sell, or serve alcohol. 24, defendant Reed walked into the Waterfall carrying a drink from CF McCarthy's. 25, at all relevant times on January 29th of 2022, while at Waterfall, defendant Reed showed signs of intoxication. Again, there's been no evidence of that. But in order to maintain a civil lawsuit against both bars, they have to prove that she was served by them while she was visibly intoxicated. In many states, this is called a dram shop action. Massachusetts does not have a dram shop law per se, but their requirements under it's not a particular provision permitting injured people to file civil claims for damages against bars, such as, for example, New York has a dram shop law and many other states do. But under their case law and common law, vendors are not permitted to serve or sell alcohol to intoxicated persons. So they have to have known that she was intoxicated and served her anyway. And in my opinion, that is going to be difficult to prove based on all of the evidence that came in, or lack of evidence that came in during the criminal trial. Where was I? 26. Between 10:54 p.m. and 11:54 p.m. on January 28th, defendant Waterfall served Reed one shot and one mixed alcoholic drink. Reed consumed such drinks. 27. On January 29th of 2022 at approximately 12:10 a.m., defendant Reed left Waterfall. On January 29th, 2022 at approximately 12:11 a.m., JJ left Waterfall. 29. At all relevant times on January 29th of 2022, between 12:11 a.m. and 12:36 a.m., defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. 30. At all relevant times on January 29th of 2022, defendant Reed drove JJ to the residence of 34 Fairview Road in Canton, Norfolk County, Massachusetts. 31. Defendant Reed and JJ had been in an argument on the night of January 28th of 2022 into the early morning of January 29th of 2022. How do you think they're going to prove that? Who's going to testify to that? Jennifer McCabe? 32. After JJ got out of defendant Reed's vehicle in front of 34 Fairview Road on January 29th of 2022, Reed drove her SUV and hit JJ. 33. At all relevant times on January 29th, 2022, defendant Reed drove her SUV in a state of intoxication. 34. As a result of Reed's SUV hitting JJ on January 29th, 2022, JJ was knocked down onto the ground in front of 34 Fairview Road, suffered serious injury, and died. 35. After hitting JJ with her SUV, defendant Reed fled the scene and returned to JJ's residence at 1 Meadows Avenue. 36. At all relevant times, defendant Reed knew that it was snowing, knew there was an impending blizzard, and knew or should have known that leaving JJ outside in the blizzard would likely result in serious injury or death. I think after that trial, we all knew that it was snowing. 37. At all relevant times, when defendant Reed drove her SUV and hit JJ, defendant Reed, A, failed to use any care to avoid creating an unreasonable risk of harm to the public and JJ. B, voluntarily took an obvious risk under the circumstances, knew or should have known that death or serious injury was reasonably predictable. C, persisted in a clearly negligent course of conduct over a noticeable period of time. D, was impatient with reasonable precautions. E, was deliberately inattentive to the predictable hazards of her actions. And or F, was deliberately inattentive when there was a risk of great and immediate danger. At all relevant times, when defendant Reed drove her SUV and hit JJ, defendant Reed was reckless when A, she intended the reckless conduct that resulted in JJ's injuries or death. B, her conduct made it highly likely that someone, namely JJ, would suffer serious injury and die. C, she knew or had reason to know of the risk of grave injury or death to JJ, or said risk would have been obvious to a reasonable person, and she intentionally or unreasonably disregarded that risk. E, JJ's injuries or death resulted from defendant Reed's decision to engage in the conduct referenced above in 16, 17, 26, and 37 AD. 39. On January 29th, 2022, at approximately 4:30 a.m., defendant Reed knew that she hit JJ with her SUV. Nevertheless, she woke up JJ's 14-year-old niece, Kaylee, and talked about JJ's death, talked about hitting JJ with her SUV, and otherwise involved Kaylee in her frantic calls about JJ's death. 40. At all relevant times on or about January 29th of 2022, defendant Reed knew that Kaylee was a vulnerable minor who already lost her parents tragically and depended on her custodial uncle, JJ, who became her surrogate parent. 41. At about 5:07 a.m. on January 29th of 2022, defendant Reed left One Meadows Avenue. 42. Between 5:18 a.m. and 5:35 a.m., defendant Reed knew JJ was seriously injured, buried in the snow, and laying on the ground in front of 34 Fairview Road, Canton, where defendant left JJ to die hours earlier. 43. On January 29th of 2022, defendant Reed admitted repeatedly that she hit JJ. Who's going to testify to that? Who's going to be deposed about that? They're going to have to depose. Here's what happens in a civil case. Okay, discovery is so liberal. This is not like Judge Cannoni's criminal courtroom where you have to make a Rule 17 motion to get records and you don't get depositions in criminal cases. This is the floodgates are open. Guess who's coming back for a deposition? Carrie Roberts, Jennifer McCabe, Brian Albert, Brian Higgins, everyone in the house, Timothy Nuttall, Katie McLaughlin, all the first responders, everybody who is under internal affairs investigation, they're all fair game. In addition to, because you're going to see that these are emotional claims, the entire medical histories of Paul O'Keefe, Peggy O'Keefe, the father, Mr. O'Keefe, and Kaylee. At least their psychiatric histories and their medical histories, because when you're claiming a medical injury and a psychological injury, your entire history medically is fair game. Why are they doing this to this child? Hasn't she suffered enough? My opinion. I agree, Ed. Bad move to sue now. Hi, Ed Wallace in the house, everyone. Ed Wallace. Every time I see your profile picture, it confuses me because you are so much better looking than whoever that guy is. Sound like Mel Gibson in some crazy movie? I don't know. But hi, Ed. Thanks for so much for chiming in because I agree. People keep saying in the chat, please stop spreading misinformation. The statute of limitations was not about to expire. It does not expire. It is a 3-year statute from the date of death. It expires January 29th of 2025. They had plenty of time. All this is going to do is start the ball rolling, perhaps, on discovery in the civil case, which is going to be free for Karen Reed because her auto insurance carrier is going to pick up the defense here. That's why you have car insurance. That's why you have auto insurance. They assign attorneys to represent you in any case that's brought against you for a car accident. So it's free, my friends. It's free. Oh, and by the way, for all of you that donated yesterday to the Karen Reed Defense Fund in honor of her dad's birthday, I think Kelly told me they raised something like $13,000 yesterday in one day. So thank you to everyone. It was his 76th birthday. And we said maybe everyone could donate, or whoever can donate $7.60 in honor of his birthday. And so many of you did. And I think they raised like $13,000. Okay. Back to the document. So she admitted repeatedly that she hit JJ. They're going to have witnesses to that. 44. At or about 6:03 a.m. on January 29th, 2022, defendant Reed arrived at 34 Fairview Road, Canton, and immediately observed JJ lying on the ground, buried in the snow, where she had earlier left him to die. 45. At all relevant times on January 29th of 2022, JJ suffered trauma injuries before becoming hypothermic. That's interesting. because there may have been other ways that he suffered trauma injuries. And that's what I'm going to suggest to the defense on this. But I'm sure they don't need my suggestions, but we're going to talk about that in a minute. 46. At or about 7:50 a.m. on January 29th, 2022, JJ was pronounced dead at the hospital. May God rest his soul. And justice for JJ. Or justice for John O'Keefe, officer, Boston police officer John O'Keefe. 47. At all relevant times after 7:50 a.m. on January 29th of 2022, defendant Reed went to the grieving house of JJ, feigned comfort to JJ's family, and used the opportunity to, amongst other things, remove the offending weapon, her vehicle, and or destroy relevant evidence. Well, that's an interesting choice of words, isn't it? Because it says here that she feigned comfort to JJ's family. Nobody testified to that. In fact, Paul testified that she just came in, went upstairs, and left. Wasn't even nice, wasn't even comforting in any way, shape, or form. So I'm surprised about this little clause right here. But now she went there only to remove the murder weapon and destroy evidence. Who's going to testify to that? The children have already testified. You remember it was a closed courtroom that day, but there was some tweeting from the courtroom. Jess Machado was on a show with me. I think we were on LTL True Crime and or Brian's show together. And the niece and nephew testified that Karen did not have access to the ring footage. So I'm not sure what relevant evidence they're going to claim that she destroyed, but okay, let's do some discovery on that. 48. On January 29th, 2022, defendant Reed's blood was drawn reading of 93 milligrams per deciliter. It doesn't say what time, you notice. A serum conversion and retrograde extrapolation was done on the results of the defendant Reed's blood, with the results showing her BAC would have been between 0.13% and 0.29% around the time she drove the SUV and hit JJ. Notice also they didn't put a time in here as to when she hit him. This, in my opinion, is a big nothing because we don't know what she did after she went home. And we know the witnesses that testified about this extrapolation evidence. And they were so honest. And they're like, yeah, it's a huge swing. Yeah. Can't really prove it. Yeah. We didn't have the whatever proper draw that we needed. It may not have been done properly. This is all, in my opinion, probably not admissible, even in civil court, because really there's no way of showing her BAC at the time. Typically when someone's pulled over for drunk driving, they'll blow at the scene and they'll have a reading at the scene, which isn't contemporaneous with the event, either at an accident scene or just getting pulled over for drunk driving. Or if you're brought to the hospital and cuffed to the bed, they will send someone from the police department to take your blood or a technician of some sort. And so it's contemporaneous with the event. This is not. This was hours and hours later, and anything could have happened in the meantime. She could have gone home and drank a bottle of vodka. Nobody knows. 49. Reed's BAC of 0.13 to 0.29 all exceeds the legal limit to drive a motor vehicle in Massachusetts. 50. At all relevant times on or about January 29th, 2022, defendant Reed drove her SUV while under the influence of alcohol and hit JJ with her SUV. 51. As a direct and or proximate cause of Reed's drunk driving, JJ sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. 52. Notwithstanding her Fifth Amendment right not to speak, defendant Reed chose to speak publicly. She knowingly and deliberately changed her story and fabricated a conspiracy, knowing the same to be false. She publicly communicated this false narrative, thereby frustrating justice for JJ. Such false narrative caused the plaintiffs aggravated emotional distress. Oh, I see an opening here to depose Michael Morrissey, if anybody's wondering, because wouldn't that be fun? Who else was out there spreading information about this case publicly. Michael Marcy in his hostage video. 53, the plaintiffs listed above bring this complaint seeking full and complete, all in caps, justice for JJ. I'm just going to tell you that that's a weird paragraph to put in a personal injury lawsuit. But I didn't draft this. So, but then again, this gives you the motivation for this lawsuit. The plaintiffs listed above bring this complaint seeking full and complete justice for JJ. Do they think that this lawsuit is going to bring justice for JJ by getting them money? Because that's the only thing they're going to get from this is money. If they succeed, which I do not think they will. But let's move on. Count one is the estate of John Joseph O'Keefe. So it's the estate of John O'Keefe versus C.F. McCarthy's wrongful death. They're going to allege this also against the Waterfall, so I'm only going to read it once. Defendant C.F. McCarthy negligently served alcohol to an intoxicated person, namely defendant Reed. Defendant knew or should have known that defendant Reed was intoxicated at relevant times of service on January 28th of 2022. Let's think about this. C.F. McCarthy's, who else was there? John was there. Kurt Roberts was there, Carrie's husband, right? But he had to leave early. Otherwise, Carrie was going to be in a mood, right? And so that's why John was calling Karen to come there so she could drive him home. Because remember, at autopsy, Officer John O'Keefe's blood alcohol content was 0.28. And that was a few days later. So Kurt Roberts was there. Did he testify that Karen was hammered and that she was visibly intoxicated? I don't think so. We saw video from the bar. Did the video from the bar show that she was visibly intoxicated? And here's the other thing that's going to happen now. Now, Karen Reed, C.F. McCarthy's, and the Waterfall are all on the same team. Their interests are now aligned. That's a problem in the criminal case, and that's a problem for the McCabe's and the Alberts. Because now they're going to have a team of defense attorneys. Because again, C.F. McCarthy's has insurance. Waterfall has insurance. Typically, insurance defense firms are big firms that are used to defending these types of cases, and this is what they do. It's not going to cost C.F. McCarthy's, the Waterfall, or Karen Reed anything to defend this case. That's why they have insurance. And insurance companies don't like to pay. If they settle the lawsuit like the C.F. McCarthy's or Waterfall, could it affect their liquor license? Do you think that they're going to risk settling this case to get out of this case and potentially risk their liquor license? I don't think so. I don't think so. But now they're all in the same team and they're in it together, right? I know there are a lot of you in the chat, some of you who are adjusters or BI adjusters for insurance companies or used to be. Insurance companies just don't pay claims just because. I do not think, somebody said, do you think they're just going to settle? No, I don't think so. Why would they? Their reputation's on the line, their liquor license is on the line, their insurance rates are on the line. And they know that she wasn't hammered. There's no evidence of that. In a civil case, to prove a case against a bar like this, you have to show that they served a person who was visibly intoxicated. And I don't think that they can show it. Who was the other person that was with Paul and Kurt? I think, wasn't there another guy with them? I can't remember who it was. And I don't even know if he testified at the trial. Yes, he did testify. It was his friend that drove him there. Camerado, right. Thank you. Michael Camerano. Right. Michael Camerano and his wife both testified. His wife was the nurse. Yep. Good guy. None of them testified that Karen was hammered. Were they even asked? Now I have to go back and watch their testimony. Hmm. Defendant C.F. McCarthy violated Massachusetts dram shop laws, company safety policies, and was otherwise negligent for numerous reasons, including but not limited to its decision not to hire competent employees, staffs, bartenders, servers, its decision not to provide adequate personnel to work at C.F. McCarthy's at relevant times, its decision not to provide adequate safety training to its employees, staff, bartenders, servers, its decision to violate its safety training, its choice to retain unfit employees, staff, bartenders, and servers, its choice to not supervise adequately its employees, staff, bartenders, and servers. 57. The defendant C.F. McCarthy's acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. The defendant C.F. McCarthy's acted with gross negligence. The defendant C.F. McCarthy's acted with willful, wanton, and reckless disregard for the safety of others when it served an intoxicated defendant Reed. The defendant C.F. McCarthy's deliberately ignored the appreciable risk and or voluntarily incurred the obvious risk of serving defendant Reed when she was already intoxicated. C.F. McCarthy's persisted in serving Reed alcohol well after it knew that defendant Reed was visibly intoxicated. Defendant C.F. McCarthy's continued to serve defendant Reed alcohol at relevant times when Reed was already intoxicated. 62. As a direct and proximate result of defendant C.F. McCarthy's negligence, gross negligence, and or willful wanton disregard for safety, JJ sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral expenses, and died. As a direct and proximate result of defendant C.F. McCarthy's negligence, gross negligence, and or willful wanton disregard for safety, JJ's next of kin suffered as well. JJ's next of kin are entitled to JJ's lost value resulting from his wrongful death. Such damages include, but are not limited to, reasonably expected society, companionship, comfort, guidance, counsel, net income, services, assistance, protection, care, and advice to each next of kin. So in a wrongful death lawsuit, there are two types of damages that you can collect. There are pecuniary loss, and then there's loss of parental, they call it in New York, parental care and guidance. Or if you're married, it's loss of consortium, loss of services. You'll never have relations with that person again. You won't be able to guide your children anymore. That has a value, as well as the pecuniary loss, which is the lost income. How old you are on the date of death versus how long you would have worked for. All of that is lost income. When you add that up and then you present day value it, it's lots of calculations. You need an economist to come in and testify about that. Pension, health insurance, all that stuff is pecuniary. And then there's the damages for things that are more like emotional damages, like loss of parental care and guidance. And then they're calling it assistance, protection, care, and advice to each next of kin. Wherefore, the estate of John O'Keefe demands judgment against C.F. McCarthy's on count 1, plus cost, compensatory, and punitive damages, lost value to next of kin, and any other relief this court deems appropriate. I'm going to tell you that punitive damages in Massachusetts are very, very, very difficult to obtain. There was a recent case against Philip Morris where a woman who had smoked for 40 years died of lung cancer. And I don't remember the exact numbers, but that was a case where punitive damages were awarded against Philip Morris. Getting punitive damages in a case such as this it's going to be very, very difficult, if not impossible. Then they have the same count for wrongful death against Waterfall Bar and Grill. And they allege that Waterfall negligently served alcohol to an intoxicated person, namely defendant Reed. Defendant Waterfall knew or should have known that defendant Reed was intoxicated at relevant times of service on January 28th of 2022. Then they're going to say how they violated the dram shop laws again, which is the same as against C.F. McCarthy's. They're also alleging they acted with gross negligence, which may entitle them to punitive damages, but in my opinion, it won't. Even if all of this was true, it wouldn't. Defendant Waterfall acted with willful want and reckless disregard for safety. I just want to see where the actual facts are here. I thought it said somewhere that they served her 2 drinks. Hold on. Where does it say that they served her 2 drinks? Maybe it comes later, but I thought I saw that in there. Count 3. This is the estate of John O'Keefe against Karen Reed for wrongful death. Let's just go to some questions for a minute while we have a moment here. There are lots of questions. Susan Costello, thank you again so very much for your super sticker. $50. You are amazing. Hope, thanks for being a member for 3 months. Says, good morning. I got so excited when I see the live notification. Love you, Melanie. Love you too. Love you right back. Dawn says, we all know Paul knows firsthand about drunk driving. If you know, you know. You're right, Dawn. You are right. And in fact, he caused serious injuries to another driver. He was arrested for drunk driving, and Karen Reed bailed him out of jail. All the information's out there. You can find it if you want to. Fairy Raven says, thanks, Fairy Raven, for tuning in from Ireland. Hey, Melanie, I think Paul has been brainwashed and his hatred of Karen is misdirected, but I do think it's greed for monetary gain. Thank you for chiming in with your thoughts, Fairy Raven, as always. Deirdre Sargent, thanks for the 10. Will this lawsuit foreclose them from suing McAlberts when it comes out they did it, since they knew or should have known via Karen's defense who really did it? So statute of limitations will have run. That's a great point. But in my opinion, if I was defending this case, the first thing I would do is file a third-party complaint against the people that the defense thinks really did cause John O'Keefe's death. So what I think is going to happen, and it's going to happen, and it has to happen within 20 days of them filing their answer, is a third-party complaint against third-party that makes Karen a third-party plaintiff. And hey, if the bars join in too, even better, right? They can file a third-party complaint against Brian Albert, Brian Higgins, and anyone else they think may have been responsible for the death of Officer John O'Keefe. And you know what that does? Boy, does that open the floodgates of discovery. Doesn't it? And you know what else that does? It's a problem for Brian Albert and Brian Higgins and whoever else they choose to sue as a third-party defendants, because insurance isn't going to cover that. They're going to have to pay for that defense themselves. So, if these people are now their friends, because I've heard you guys have told me that they may have gone on vacation together, Paul O'Keefe may have be friends with all of these people now. He's potentially opening up those people to a lot of liability, financially and otherwise, because even if they have homeowners insurance, there's a notice problem. When you're involved in any kind of, or have reason to believe that you may be involved in a lawsuit, you have an obligation to notify your insurance company in a timely manner. And if you don't, they can disclaim. So that's a problem. If they're third partied in, let's say, for example, Brian Albert, Brian Higgins, Colin Albert, right? Because Karen said Colin, Brian, whatever. Boy, does that open the floodgates of discovery. And everything in a civil case is fair game. Nothing at a deposition, nothing's even objectionable. Just because it may not be admissible at trial is not a reason for an objection at a deposition. It all has to be answered. It's all coming out. So you better want what you wish for in some cases, because these potential third-party defendants, which I think they will be, are now going to be open. I can't even tell you how much it's going to cost to defend a case like this, because the depositions alone are going to cost a fortune, because there's going to be a lot of them. And all the discovery that's collected during this civil case is going to go to potentially help Karen in her criminal retrial. See what I'm saying? So yeah, That's a problem. Great question, Deirdre. Laren, hi, Laren says she may have purchased drinks for others. Yes, that's true. But also, where are the receipts? The only receipt we saw was from Waterfall, 2 Tito's and a beer and a beer. And that I don't even know if that was her bill, someone else's bill. We don't know. There's really no proof of it. There's people who are going to testify that she was drinking clear liquid. Remember Karina Kolakithis and her husband talking about how lovey-dovey John and Karen were in the bar, and how when Karina went home, she even said something to her husband like, "How come you don't treat me like that in public? They're so lovey-dovey. Why don't you act like that towards me?" She was one of my favorite witnesses in the whole criminal trial. Absolutely correct, Laren. Truth be told, thanks for the 5. Can Karen file cross-claiming to include, I don't know what that, Maxine, I don't know what that is, and Higgins. Maybe that's a typo. But yeah, she would third party them in as third party defendants, saying, I'm not responsible for this. They're responsible for this. That would be the first thing I would do if I was the defense attorney in this civil action. Deirdre Sargent again says, can Karen claim, even if she was drunk, that John, the DUI trained police officer, assumed the risk when he got in a car with his obviously drunk girlfriend? I don't really see that as an affirmative defense here, but I think she's just going to deny everything, deny it all. So I don't know. We'll have to see when the answer comes in. They have, after they're served with this complaint, I think they maybe have 30 days to answer, 20 days to answer. I'm not sure. But as soon as that answer comes in, we'll take a look at it. North End Andrea, thanks for the 5. Why would a lawyer agree to file this at this stage? I don't know. I think you mean at this stage. How can they prove some of her drinks were not water? Thank you for your expert insights on this ongoing circus. I don't know. Did they have pressure from their clients to file it now? Because if they waited to file it until the statute was about to run in January, the retrial would presumably happen first, right? And even if she's found not guilty, they could still proceed with a civil case, because remember what happened in OJ. OJ was acquitted and the civil case was successful. So that's a great question. I don't know why. I don't know if the family was pressuring them. I don't know if, they're trying to just put more pressure on Karen, but now they've alienated CF McCarthy's in the Waterfall too. So it's not a great move in my opinion, but it's just my opinion. And that's what you're here for. And I'm going to give it to you. I'm not going to just read this and be neutral and not tell you my opinion, because why else would you watch? RJ NLC, thanks for the deuce. This doesn't have to be based on established fact. Well, there are no established facts because that's up to a jury. The jury is the finder of fact. In some cases, like on a motion for summary judgment, the judge is the finder of fact. And we're going to go through some more of these causes of action. And I'm going to tell you which causes of action I think are going to be thrown out on paper or on motion. Cat's meow. Thanks for being a member for 3 months. Thanks for breaking this down. We love you, Melanie. Thank you. I love you too. Lisa, thank you, Melanie, for being awesome. Free Karen read. Thank you, Lisa. Thank you all. Thank you. Thank you all. Sarah and Shankanhara, thanks for the 5. I just saw your sub count finally moved from 66.6K. Congratulations. Thank you. Lori Lake 360 for the win. Thank you for the 10. Most of the civil witnesses lied during the criminal trial. How does that work? Seems they will lie again. Thank you. I so enjoyed here. Well, they're called in to testify at a deposition. They will once again be testifying under oath. And then that deposition is sworn testimony and could be used in the criminal trial. So if they contradict themselves with regard to what they said during any of the grand juries or their testimony during the criminal trial, that's going to work against them. So we'll see. But perhaps there could also be other witnesses who were not called at trial. The bartender from CF McCarthy's, he didn't come in and testify, right? The bartender, I think from the Waterfall testified, but she really didn't have a lot to say, except for I think John was a good tipper. And she knew the Alberts, because they were in there all the time. Thanks, Lori, for your generosity. DK, thanks for the 20. Love my show. Thank you. Quick weird theory. Is Paul finally turning on the McAlberts? And this is a way to expose them without stating it publicly, forcing them back up on the stand. And new discovery perplexed why he would file now. I am too. No, I don't think that he has turned on them. But what I think is going to happen, maybe, is that once some of them are third partied into this case and it's going to cost them a fortune to defend, they may turn on him. Like, I don't know. I don't know who's turning on who. And I like to stay out of the drama, but it's a great question because I don't understand why they wouldn't just wait until the statute was about to expire and see what happens with the retrial. Doesn't make any sense to me. I don't know if they can stay this case pending the criminal trial. I don't think that they can. I don't know if they can force Karen Reed to be deposed before the criminal trial. So there are a lot of questions here, and I don't know. But I heard, or you guys have told me, or somebody just said in the chat that they just went on vacation together. J. Michael RN, thanks for being a member for 2 months. Wouldn't the independent and intervening acts of the Waterfall make it harder to find liability on CF McCarthy? No, because they're alleging that CF McCarthy served her 7 drinks when she was visibly intoxicated, and then the Waterfall only served her 2, but she already had 7. So see how that works? It's a compounding. But then again, there's been no testimony that she was visibly intoxicated. And in order to succeed in a civil claim against both of the bars, you have to be able to show that. I don't see how they're going to do that. And thank you, 10, 11, 12, who says here every day for opinion. Well, you're amazing. Thank you. All right, moving on to count 3, which is wrongful death against Karen Reed. We have over 3,000 people here right now, and we only have like 1,000 likes. And that I will turn off the air conditioning, my friends. You know I will. Turn it off. I'll make you watch the fan. Please hit the like button. It helps the algorithm, helps the YouTube-ish things. Thank you so very much. You might have to close out the chat. They've changed the format of YouTube to be able to hit that like button. Paragraph 75 says, on the date of the crash and at all relevant times, defendant Reed owed JJ and the public at large a duty not to drive drunk, to drive her vehicle safely and or with due care. On the date of the crash and at all relevant times, defendant Reed owed JJ and the public at large a duty to pay attention on the roadway. On January 29th, 2022, and at all relevant times, defendant Reed breached her duties of care to JJ by driving drunk, driving in an unsafe manner, and or without due care. As a direct and or proximate cause of defendant Reed's negligence, gross negligence, and or willful, wanton, and reckless disregard for safety, JJ sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. As a direct and proximate result of defendant Reed's negligence, gross negligence, and or willful, wanton disregard for safety, JJ's next of kin suffered as well. JJ's next of kin are entitled to JJ's lost value resulting from his wrongful death. Such damages include, but are not limited to, reasonably expected society, companionship, comfort, guidance, counsel, net income services, assistance, protection, care, and advice to each of the next of kin. Wherefore, the estate of John O'Keefe demands judgment against the defendant Karen Reed on count 3 for all damages to which the estate is entitled to under MGL 229 Section 2, compensatory and punitive damages, lost value to next of kin, and any other relief this court deems appropriate. And here's where we get into what I consider to be the tenuous claims at best. And this is Peggy O'Keefe, Margaret O'Keefe versus CF McCarthy's. This is negligent infliction of emotional distress. Margaret O'Keefe was the mother of JJ. Margaret O'Keefe learned of JJ's admission to the hospital immediately and came upon JJ's body at the hospital shortly thereafter. CF McCarthy's negligence caused the death of Margaret's son, JJ. Margaret suffered severe and profound emotional injuries manifesting in physical symptoms as the result of observing JJ at the hospital and witnessing the consequences of CF McCarthy's negligence. Margaret's emotional injuries, severe physical pain, anguish, emotional distress, and or other harm were directly and or proximately caused by the defendant CF McCarthy's negligence. A reasonable person in the same position as Margaret O'Keefe at the time of JJ's death would have suffered severe and profound emotional distress. Wherefore, plaintiff demands judgment against the defendant, C.F. McCarthy, on count 4, plus interest, costs, and other relief or damages the court deems appropriate. Okay. So they are basing their claim for negligent infliction of emotional distress solely upon their viewing of JJ's body at the hospital. They are saying that that is what caused them emotional distress, not the death, the seeing of the body, observing JJ at the hospital. Same cause of action for father, the dad, John O'Keefe, negligent infliction of emotional distress for seeing JJ's body at the hospital. Paul O'Keefe, negligent infliction of emotional distress against C.F. McCarthy's for the same thing. And they are alleging that Paul suffered severe and profound emotional injuries manifesting in physical symptoms as the result of observing JJ at the hospital, witnessing the consequences of C.F. McCarthy's negligence. This is what I was talking about when I tell you that when you file a claim like this, your entire medical history and psychiatric history comes into play. It is discoverable. And you also need to prove that you have sustained some sort of, there needs to be psychiatric treatment, something after this event that you've told to your doctor, psychiatrist, psychologist, counselor, that seeing JJ's body in the hospital caused you severe, not only emotional distress, but physical symptoms as well. There needs to be medical proof of that. You can't just come in and testify and say, yeah, I was really upset about it. For a long time, I couldn't sleep. I had insomnia. I had nightmares. I needed to take, you need a doctor to verify all of this. Same causes of action against the Waterfall for negligent infliction of emotional distress, for witnessing JJ's body in the hospital, for Margaret, for her husband, John, and for Paul, all against the Waterfall bar. And then count 10 is Margaret O'Keefe against Karen Reed for negligent and or reckless infliction of emotional distress. Margaret O'Keefe was the mother of JJ. Margaret O'Keefe learned of JJ's admission to the hospital immediately and came upon JJ's body at the hospital shortly thereafter. Defendant Reed's negligence caused the death of Margaret's son, JJ. Margaret suffered severe and profound emotional injuries manifesting in physical symptoms as the result of observing JJ at the hospital and witnessing the consequences of Reed's negligence. Defendant Reed outrageously created a false narrative. How is she going to prove that she did not create a false narrative? By third partying in all of these other people to show that the narrative that she created may in fact be true. One sec. Thank you, Scott. Margaret suffered severe and profound emotional injuries manifesting, I said that already, right? The false narrative, yep. Margaret's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or approximately caused by defendant Reed's negligence. A reasonable person in the same position as Margaret O'Keefe at the time of JJ's death would have suffered severe and profound emotional distress. Count 11 is the father, John O'Keefe, against Karen Reed for the same cause of action, negligent or reckless infliction of emotional distress. for seeing his body in the hospital. Count 12, same cause of action. Paul O'Keefe against Karen Reed for the same negligent and or reckless infliction of emotional distress for viewing his body in the hospital and for her outrageously creating a false narrative. Count 13 is Kaylee versus Karen Reed, negligent, reckless, and or intentional infliction of emotional distress. And this is a different cause of action because Kaylee did not go to the hospital and see her uncle's body. But here's what they claim Karen did to cause negligent, reckless, and or intentional infliction of emotion. So this is the only cause of action that they say is intentional or maybe intentional. At all relevant times, Kaylee was the niece of JJ. JJ was her guardian since her parents passed away. Kaylee learned of JJ's death or injury when defendant Reed woke Kaylee up at approximately 4:30 a.m. on January 29th of 2022. Defendant Reed knew Kaylee was vulnerable, having already lost her parents at age 6. Nevertheless, in Kaylee's presence, defendant Reed spoke on speakerphone to various people between 4:30 and 5 a.m. on January 29th of 2022. What various people did she speak to? Put them in the chat because some of them, I believe, have not been called to testify at trial. Carrie Roberts, Jen McCabe, and I think there was one more. So it's interesting that they don't name them here. That'll be for a bill of particulars or interrogatories or whatever form of written discovery Massachusetts uses in their civil cases. At all relevant times on January 29th, 2022, Kaylee heard defendant Reed say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. As a result of the conversations defendant Reed had in her presence, Kaylee perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury producing event. So they're saying that because Kaylee overheard Karen say these things, allegedly, that it made her imagine what had happened to him, causing her emotional distress. She perceived the injury producing event. At about 5 a.m., after waking Kaylee up and informing her that something happened to JJ, defendant Reed left Kaylee home alone. Defendant Reed intentionally and or recklessly inflicted severe emotional distress when she woke up Kaylee and informed her that she hit her uncle or that a snowplow hit her uncle. Well, she didn't say she hit him. According to this paragraph 150, they say she said, maybe I did something, maybe a snowplow hit him, maybe I had hit him, maybe I hit him, maybe he got hit by a plow. So in paragraph 152, or 153, they're now changing it to say she woke up Kaylee and informed her that she hit her uncle. She never said I hit him. Again, I hit him, I hit him, I hit him. She didn't say that. Or that a snowplow hit her uncle. Defendant Reed either intended to inflict emotional distress on Kaylee or knew or should have known that emotional distress was likely a result from defendant Reed's conduct. Defendant Reed's conduct was extreme and outrageous, beyond the bounds of decency, and was utterly intolerable. That's what they need to show in order to show a claim for intentional infliction of emotional distress. That her conduct by saying these things, if it's true that she said these things, was so extreme and outrageous and beyond the bounds of decency and was utterly intolerable. And I don't think that even if we take that as true, that it reaches that level, in my opinion. This reminds me of the case of the Petitos against the Laundries, the civil case, but that was in Florida, and they have much more liberal rules in Florida. And that case did eventually settle. Then, after JJ was declared dead, the defendant Reed came to the family house and feigned concern. Rather, it became clear that defendant Reed was only there to collect her belongings and to take possession of the murder weapon. The emotional distress suffered by Kaylee was severe and of a nature that no reasonable person should be expected to endure it. Defendant's extreme and outrageous conduct caused Kaylee aggravated emotional distress, manifesting in physical symptoms. Kaylee also suffered severe and profound emotional injuries as the result of perceiving JJ's death and or the injurious producing event, the consequences of Reed's negligence. Then defendant Reed outrageously created a false narrative. Kaylee's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or approximately caused by defendant Reed's actions. A reasonable person in the same position as Kaylee at relevant times, including the time of JJ's death, would have suffered severe and profound emotional distress. And what this cause of action does is subject Kaylee to days of deposition testimony, puts her entire medical history and psychological history, and psychiatric history as fair game. And I'm going to submit to you that she may have been seeing a therapist since her parents died. I mean, it was tragic what happened to her and her brother. Her mother died very quickly after being diagnosed with a terrible disease. And then I think within 6 months later, her father also died. So this young child, who I think was 6 at the time that Officer John O'Keefe took guardianship of her and her brother, lost both her parents, I think before she was 6 or 8. And then she loses her uncle. It's tragic. But her entire psychiatric history is now fair game. And I don't know that that's fair to do to this poor girl. Hasn't she been through enough? They called her in to testify at the criminal trial, which really, was it worth it? Was it worth it? And then, first of all, I think this is a tenuous argument at best, because I don't think the conduct was outrageous, even if it was true, and so beyond the bounds of decency and so egregious to reach the level of an intentional infliction of emotional distress. Is it worth it for this child? I don't think so. That's my opinion. Plaintiffs demand a trial by jury on all counts, and here's their attorney, Mark Diller of Diller Law from Boston. So, in my opinion, negligent infliction of emotional distress cases are very, very difficult to prove. And in order to succeed on such a case, you have to show certain things. Let me put myself back full screen. Negligent of infliction of emotional distress cases have typically been used in cases where, for example, a mother is pushing her baby in a stroller across the street. The stroller is hit by a car and her baby is killed, and she sees it happen. That is negligent infliction of emotional distress, because you are physically there. The person who is killed or injured is a blood relative of yours, and you are within what they call the zone of danger. So not only do you witness this happening, but you too could have been injured. Okay. That's typical going back to law school type case law. Zone of danger. It is not meant to be extended to going and seeing a person in the hospital and witnessing injuries. It's just not meant to extend to that. Massachusetts, this issue has been litigated several times, obviously, in Massachusetts. And in my opinion, I've read some of the cases. I just don't think it's going to extend to this. If they were present when the accident happened and saw it happen, it may. But it is not so contemporaneous in time with the event or the location that those cases are going to succeed, in my opinion. I think they're going to be dismissed on motion. I think they could be dismissed without even doing any discovery. And I think on the face of the pleadings alone, those causes of action should be dismissed. That's my opinion. Who knows? Massachusetts seems to be the world of the wild, wild west. But I don't think that Paul, Peggy, and Mr. O'Keefe are going to be able to succeed in any negligent infliction of emotional distress claims against C.F. McCarthy's The Waterfall or Karen. The one that may have a little bit more legs is Kaylee, but then they are going to have to say or prove that based on the pleadings, and that is just what is set forth in this complaint. When you decide a motion, you have to construe the facts as alleged in the complaint in the light most favorable to the plaintiff. So even assuming that Karen said all those things for purposes of a motion to dismiss that cause of action, I don't think that Karen saying, maybe I hit him, I could have hit him, I'm worried he's not home, maybe a snowplow hit him, rises to the level of extreme and outrageous conduct to succeed on a negligent or intentional infliction of emotional distress claim. What I also find interesting in this lawsuit is that there are causes of action for negligence. And they are alleging in the criminal case that she intentionally ran him down and killed him. Intentionally. There's no allegations of intent in this lawsuit. It's based on negligence. So which is it? Can they be cross-examined about this complaint in the criminal trial next time Paul gets up on the stand? But isn't it true, Paul, that you filed a lawsuit against Karen and you said she was negligent? You didn't allege that she intended to kill your brother. You allege that she was negligent. So which is it? How can they now try a case for second-degree murder or whatever that count one was when they're only alleging negligence in this lawsuit? And also, now, doesn't this make any testimony by Paul biased because he's got a financial interest in the outcome of this civil case? What say you? Mama She, thanks for the $10 super sticker. I appreciate you. Harry Raven, do you know if the FBI ARCA folk can be revealed in the civil suit? Well, they could use them as experts to show that there was no car accident, because the crux of this lawsuit is they're going to have to prove there was a car accident. Is there a motor vehicle accident report? Because I've been asking about that all pretrial and I never got a real answer to that. Because in New York, when there is a motor vehicle accident causing personal injury or death or property damage over a certain dollar amount, an MV-104 has to be filed with Albany. It's a requirement. It's the law. Did they ever make out a motor vehicle accident report? Canton PD? MSP? Did anybody ever make one out? I don't know. You're saying, can it be revealed that they were from the FBI? Civil court's a lot more lenient with regard to discovery and with regard to admissibility. So that's a great question. Jadzia, thanks for becoming a new member. Magnolia Gypsy, does this mean psych evals? Yep. Yep. It also opens them up to IMEs or independent medical exams. Anybody who's ever been involved in a car accident knows about IMEs. Your insurance company sends you after you have a certain amount of treatment to their doctor to say there's nothing wrong with you so they don't have to continue to pay. But in civil cases, yes, they get independent psych evals by an expert of the defendant's choosing. So yes, it opens them to that as well. Misadventurous Bookmouse, thanks for the 5. I think it's something to do with Aiden finding dirt on an involved cop through his own trial discovery. CF and Waterfall supporting Turtle Boy openly. Paul hates Karen and Aiden. I don't know. But that's an interesting point. I didn't know anything about that. Thank you, Misadventurous Bookmouse, for your 5. Husky Lover 148, thanks for being a member for 5 months. If Kaylee said this nonsense, I would like to believe that Lullaby Lolly would have made a point to bring this up during her testimony. Love you. Thank you. Did they bring it up during her testimony? Because it was a closed courtroom that day. And so I don't know exactly what she testified to overhearing or if she was even asked. Great point. Marcello, hello from to Argentina. Thanks for your super chat. Imagine how funny it'll be If somehow Bev gets her hands on this case too, just speculating, well, it's in a different county, so she can't. She sits in Norfolk County. This is in Plymouth County. But yeah, she is a civil judge now. Also, the discovery on this case will be juicy, in my opinion. They just shot themselves in the foot. Chef's kiss, Marcello. Muy bien. Agree. Calico 26, thanks for the 5. Why are their names of the niece and nephew listed? If they are minors, don't they have to be redacted? The nephew is not a plaintiff in this lawsuit. He was not home at the time Karen was there and woke up Kaylee, so he's not a plaintiff. They don't have to be redacted as minors. I did redact them myself. In a civil case, sometimes they can refer to them with initials, but that's a good question, and they didn't do that. They could have, but they didn't. Thanks for the 5. And that, my friends, I think, looking at my notes, it's all of the thoughts that I've had. So let me look to you guys for questions. See what you guys think about this. Sebastian Anon, thanks for the 10. The timing of this suit makes me think Paul was banking on Karen being convicted, but his suit was already in motion. Now he's potentially going to affect the retrial. His greed will expose them. Yeah, it's going to potentially affect the retrial 100%. Or does he know something we don't know? And does he know that the DA is going to drop the murder charge? Because his lawsuit only alleges negligence, which would be manslaughter and recklessness, right? So we can look at that one of two ways, but I agree with you. Deborah, thanks for the 10. I wondered if Paul is deducting the amount he owes Karen from what she's bailed him out of his DUI accident. What a creep. Thank you, Deborah. Oh, Paul Revere, don't worry, I got you. I'm broke. Someone paid 99 cents to ask, how are they using new evidence if Karen's attorneys were supposed to be privy to all evidence? What do you mean? What new evidence? They all did go to see John's body at the hospital, so that's not new evidence as far as I know. The things that Kaylee overheard, she may not have been asked about on the stand, so I don't know. And there's really nothing new in this lawsuit, but they're alleging as fact the fact that she had 7 drinks and then 2 more drinks. And MJ Gaglio said it's hogwash. Yes. Disco World Edge Witch, I'm glad you said this because I'm going to say that I was going to say this too. Here's what I don't get. They hate Karen, that's clear, but why antagonize every employee at 2 local hangouts? How is that a good idea? It's not. They will be down persona non grata at every bar in town, not just Waterfall and McCarthy's. Every bar in town. Coffee Nut says Paul had to file now because if he did wait till after January, he probably would have no case when they say not guilty again. Yes, but remember OJ. OJ was acquitted and the families succeeded in a civil suit against him. I got a huge judgment against him that I don't think he ever paid. So it's more difficult, but it can be successful. So I don't know. Mandy says, I think he knows something. Most talkative. Can her attorney start depositions ASAP? Let's see what happens. They got to answer the lawsuit. In my opinion, they're going to third party in some more defendants. They got to wait for those answers. Then they usually have a conference, a scheduling conference with the court to start setting stuff up and going through discovery. So it's going to take a long time. The wheels of justice in civil court turn very, very slowly. But any depositions that they do conduct before the criminal trial are going to be fair game in the criminal trial. So I wouldn't be surprised if whoever her defense attorneys are in this case are working closely with Jackson, Yannetti, Weinberg in the criminal case. Hills of Western Mass says this will get delayed forever. We'll see. Sydney Collin, this lawsuit further exposes the Alberts, McCabe's, and Higgins. So wouldn't they be upset? That's what I'm saying. That's what I'm saying. They should be. Because not only are they going to get dragged into depositions again, but they may now be forced to defend themselves in a civil case that they don't have insurance for. So I would think so, but I don't know. Hello. Hello, who, if anyone? Brilliant. Yes. Yes, Laura. Karen gets to have psychological exam. Well, she doesn't, but they hire defense doctors to examine the O'Keefes and Kaylee to see if they were harmed by her emotionally for those specific incidents. And also, it's going to be difficult to parse out what emotional injuries are caused by just viewing his body in the hospital and, everything else that was happening around the time, his death in general. So how do you parse that out, right? Interesting question. Tinkerbell. Such a shame. I can see why John got the kids and not the other family members. It's all about the money now. And throwing McCarthy's and Waterfall under the bus. Do the owners live in Canton? I don't know. That's a great question. Do you guys know? I know that the owners are the Means for one of the bars, and I don't know who the owners are for the other, but let me know. If you guys, I know there's a lot of locals here. I know a lot of you live in Canton. Linda says, yes, I wondered that too. Does O'Keefe know the murder charges are about to be dropped? That's what I'm thinking. Why are they alleging only negligence and not intent? Mal says viewing the body is a choice. That's a good point. Archangel 807, fantastic question. Are the jurors witnesses now with their verdicts? I don't think so. But again, the rules in civil court are very, very loose. And a lot of stuff is discoverable even if it won't be admissible at trial. So that's a great question. I don't think so, but it would be an interesting tactic. Jess M would have reported it if Kaylee testified to any of that stuff. Robin, yeah, that's what I'm thinking. If the case goes to court civilly, not even goes to court, but even depositions, I'm going to take your question to mean also if people give depositions under oath, can the criminal case use that evidence? Yep. Yes, they can, because once you are deposed, that is testimony under oath that can be used in any other proceeding. So the answer is yes. CoffeeNet says Karen's parents need to sue for emotional distress. Your mom, did the suit say how much they're suing for? Maybe I missed it. No. You no longer are allowed to put dollar amounts in lawsuits, at least not here in New York, but the superior court where this is filed has jurisdiction over $50,000. So they're suing for more than $50,000. Typically, in a case like this, a car accident case, which in my opinion is not a car accident case at all, because Officer John O'Keefe was not hit by a car. There's no evidence to show that he was. You're typically limited by the amount of insurance that a person has on their car. So Karen was at the time working very savvy financially. I'm sure she had a good policy and probably an umbrella policy as well, because she's also a homeowner. So, she may have, I'm just going to throw numbers out there just for purposes of this discussion. Let's say she had a $500,000 in liability insurance and $1 million umbrella. And she may have had much more than that, right? So that's $1.5 million in coverage. The bars probably have $1 million liability policies just for round numbers. So typically you would be limited to that. And as a plaintiff's attorney, I would never go after a defendant personally for anything over the insurance coverage. So if my client had an accident and the person had $100,000 in insurance and that was all that we could get, I would never not accept the $100,000 policy and then go after a defendant personally. I just wouldn't do that. And if the client wanted to do that and take their house away, which you can't really do anyway, garnish their wages, you can only do that after a verdict. And most of the time it's not collectible. And personal injury attorneys work on contingency. So you don't pay them by the hour. They only get paid when the case settles or the insurance company pays or there's a verdict that is paid. I would never go after a defendant over and above the policy limits, because not only do you have to show bad faith that the insurance company never offered the policy, you would never be able to accept the insurance policy and then go after the defendant personally. So there's a lot of nuance to that decision. But in this case, would they try and go after her for more than the policy? Maybe. For revenge purposes, I don't know. Could it just get thrown out on motion? All those negligent infliction of emotional distress claims? I think so. The wrongful death case may go forward more longer, may go forward longer. Still waiting on the Telly's verdict, still not here yet. Um, because of all the discovery and all the discovery that can now be used in the criminal case. Danny says, great observations, Melanie. That makes a lot of sense as to why the nephew wasn't included in the lawsuit, right? I mean, the nephew stands to inherit as part of the estate. So if there's money that goes into the estate, which Paul is the representative of the estate, apparently, that money would be distributed to the heirs according to the will. I'm assuming that John died with a will. So I'm sure that, Kaylee and her brother would be entitled to some money if there ever was a wrongful death settlement or verdict, but he wasn't included for the negligent infliction of emotional distress. Heather says she didn't drink any of those drinks in the videos they showed, right? I mean, I think they're going to have a really hard time proving that. No, this would not put a lien on her house. Nope. Misty, if she was going to use the money for the second trial, that could be a thorn. No, they can't put a lien on her house. There's nothing here. There's nothing until, if ever, somebody would receive a judgment against somebody and then try and collect on it. But no. And again, her defense is free in this case because she has car insurance. That's why you have car insurance. Mega Stacker, is Paul O using the GoFundMe money funds to pay for this? That money was for the children and he has not been working. So nope. He doesn't have to pay anything. Personal injury attorneys take cases like this on contingency, which means they lay out all the expenses that they do not get paid until if and when the case settles. So he's not getting a monthly bill for these attorneys to handle this case. Doesn't cost them anything. And typically, I don't know what it is in Massachusetts and New York. It's a third. Get a third of whatever you recover plus your expenses back. I don't know. Massachusetts could be more. It could be 40%. The attorney's fee. Could be more if the case goes to trial. Depends on the terms of the retainer, which I am not privy to. Pilgrim Shadow, thank you for the 5. No Grateful Dead quote this morning. Melanie, any chance you can join Karen's team for the civil suit? It's even worse than it appears. Oh, that is a Grateful Dead quote. I don't know. Nobody's asked me, but they have insurance company lawyers that are hired, that are provided to them. If they asked me to help out on this case, I absolutely would. But be consultant. Jennifer, thanks for the 5. I believe in Massachusetts, they have 3 years to file. That is correct. January 2025 would be the deadline. That is correct. That is for wrongful death. New York, it's only a 2-year from date of death statute, but in Massachusetts, it is 3. You are very correct. Thank you so much for your 5 and for spreading the proper information in the chat. Miss Adventurous Bookmouse, thanks for the deuce. Yesterday, Aiden called him Paul O'Grift for this. Oh, but aren't we all grifters? Come grift with me. Pedro and I, we're all grifters over here. Susan, thanks for the 5. OJ never paid, but he did do time in prison because of his efforts to avoid paying. That was the robbery. He couldn't call PD due to the judgment. Yes. I think my purpose of bringing that up was just because somebody can be acquitted in a criminal case doesn't mean a civil case against them could not be successful. Thank you for pointing that out, Susan. So very much. Everyone hit the like button, please. Thank you so much. Jason says the kids are getting babysat by Jen and Carrie. Who is to say a lot of the talking came from them? Chris K says there's no way they will drop the charges against Karen. You're talking about the murder? We'll see. It's interesting fodder for cross-examination for Paul, though. Well, Paul, you don't think that Karen intentionally killed your brother, do you? Because didn't you file this lawsuit on August 26th of 2024? Didn't you allege in this lawsuit that Karen was negligent and she hit your brother in a negligent fashion? You didn't claim she intentionally did it, did you? So you don't believe she intentionally killed him, do you? So now it's going to be used against him. The same way that he told that interviewer, Christina Rex, that the reason that he had Brian Albert and Colin Albert in court on the day of closings to stare the jury down is because he wanted the jury to know that he didn't think that they had anything to do with his brother's murder. Could be turned around on him, right? Yes, you are correct about that. Hills of Western Mass thinks that Paul is killing his parents doing this nonsense. Listen, I don't know why anybody needs to go through more of this. They're already going to have to go through a retrial. And here's a reason that the attorney may not have filed anything intentional, because there's no insurance coverage for that usually. And sometimes insurance companies can disclaim for drunk driving accidents. But in a case like this, I don't think they're going to be able to prove that she was drunk. So I don't think your insurance company is going to disclaim. But if they do, that could add to further litigation that could further delay this case. So I don't understand what the upside is of filing this yesterday. I just don't. Carrie, question: if it's ever proven that John was Kate in the house, then would Paul be able to sue the McAlberts? Well, statute of limitations on that. On assault, assault is an intentional tort. So in New York, intentional torts are 1 year statute of limitations. And in Massachusetts, I'm not really sure, but negligence is 3 years. So I would say the statute on that is up unless they have some sort of data discovery rule, which would toll the statute until it was discovered that that was the case. But I'm going to say no. The only one who would, maybe, perhaps, would be the children, because the statute of limitations is tolled until you turn 18 in most states, which means it stops and then it starts to run when you turn 18. Can the jurors' affidavits be used as evidence? I don't think so. Thank you, Lisa, though, for the super chat. But I don't think so, because they were anonymous, and there have been no affidavits from jurors, actually. The only affidavits that have been filed with the court were the affidavits of the attorneys talking about what the jurors said to them, so it's complete hearsay. And it doesn't really matter what the jury talked about and what the jury thought. This is about facts, and the finder of fact in this will be the judge on motions, and then would be a different jury, a 6-person jury, if this ever went to trial, this civil case. Mm. Dear Dad, Derekashani says, I need a shower after this is all gross. Backseat juror, can the defense team work with the insurance company or request that they don't settle? Yep. I don't think they're going to pay. I mean, can't imagine that they would. You think they want to pay however many millions of dollars in coverage that she has just because? No. They litigate that's what they do. They litigate for a living, right? So yeah, I think absolutely 100%. 100%. Are they going after homeowners of the Alberts? No, they are not. They are not. Somebody asked a question earlier in the chat. I think it was pre-chat maybe, and said, can they sue the Alberts because his body was found on the lawn? And in my opinion, no. But they can sue the Alberts if they think the Alberts caused his death. See what I'm saying? Oh, a date of discovery rule. A date of discovery rule happens a lot of times in, let's say, medical malpractice cases. Let's say you have an operation. Let's say in New York, the medical malpractice statute of limitations would be 2.5 years from either the date of your operation or the date of your last visit with the doctor who performed the operation. And let's say during that operation, the doctor left a sponge in you. And let's say that you don't discover that that sponge was left inside of you until 5 years later. That may extend your statute of limitations because you didn't know that the sponge was left inside you. See what I'm saying? Nanya Ship Business, where have you been? I've been missing you. You're gonna have to go back and watch it because it was a pretty good show. It was a pretty good show. You guys have any more questions before we wrap this? Still waiting on a verdict on Robert Tellis. And what time is it there? Let's see. Oh, they just got to court. It's 9:15. Andy T 741 says, why would an insurance company pay for an accident that physically proves never happened? Exactly. 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 No, I'm not getting sick. I just have no voice because I've been talking for so long. Nurse Kim is, I don't know what that means. Nurse Kim is online. Are you redirecting people to someone else's live? Is that what you're doing, Nico 2020? Because it's not a cool thing to do, but thanks for the $2. How about Karen sue the McAlberts? That's what I'm saying. Third party them in as defendants. 100%. Artsy Mind says there was a fundraiser for the family to cover funeral expenses, etc. How can he claim those costs if the fundraiser raised $350,000? Is that fraud? Well, that's interesting. Yeah, because there would be an offset for any expenses that were paid by another source, right? Like donations. And also, if they truly believe that John O'Keefe was hit by Karen Reed's car, why didn't they go after the auto insurance carrier for the medical expenses and the funeral expenses? Because if you're a pedestrian hit by a car, the insurance company, the auto insurance company will cover those things. So did they ever even try? I don't know. Is Nurse Kim here? Oh, Nurse Kim is here. Hi, Nurse Kim. Jury reconvened about 15 minutes ago. So we'll see. They were out for 4 hours last night, which is longer than anybody thought they would be out in my poll. I think 50% of you said less than 2 hours, 48% said between 2 and 4 hours, and only 2% said over 4 hours. They've already been out for over 4 hours, but they came back with a question last night. And the question was, can we have more paper? And also, how do we zoom in on the videos? So they gave them more paper, and they also sent somebody in, a tech person, to show them how to zoom in on the video. So you know what that makes me think, Aline? They want to zoom in on that video to see if there's hair on that person that was driving that Denali. Because that was kind of a bombshell that was dropped in the defense closing. And I think they're thinking about it. That's what I think. Right? There's a sponge inside Paul's brain. Tammy says, how does the sale after the accident of the bar affect who's being sued? Do they incur the liability? The liability and the insurance policy that will cover this case goes back to the date of the accident. So whoever owned the bar on the date of the accident, the alleged accident, and whatever insurance company was in effect on the date of the accident will cover the defense in this case. Nurse Kate, did you just got here? Because Jennifer McCabe, I always credit you for that. Jennifer McCabe is gonna face a lot of questions during the civil depositions in this lawsuit. And Brian Higgins, Brian Albert, and perhaps Colin Albert may be third-partied in as defendants, and they won't have insurance to cover their defense. So they're going to incur a lot of money in legal fees, in my opinion. My opinion, because you're allowed to third party anybody into this case that you want to, who you think may actually be responsible for the death. So it's going to be interesting. I think that the O'Keefes may have just alienated a lot of people who they thought were their friends, including the owners of the bars. So if anybody knows if they were friends with the Meehan's or whoever owns the CF McCarthy's, it's going to kind of throw a wrench in there, in addition to them being persona non grata at those bars and maybe others in town. Would she have a limitation? Is a good question, Corn Pope. Of when she can implead them into the lawsuit. Usually I looked up the Massachusetts rule on this. It is within 20 days of filing your answer. So I think you either have 20 or 30 days to file an answer after service of the lawsuit upon you. And then they would have 20 days from the day they file their answer to implead any third parties without leave of the court, meaning as a matter of right, you don't have to make a motion to the court. So hope that answers your questions. Wade sentencing is at 2 p.m. today. You know who's covering that? I think Duty, Ron, and Ed are covering that. So go over there and watch it if you're interested in that. That guy freaks me out. Totally freaks me out. Iceman, can any of the witnesses, McAlberts, claim the fifth in this civil lawsuit? Well, they haven't been charged with anything. Brian Albert, Brian Higgins. So typically, no. Just because it may not be admissible at trial doesn't mean they don't have to answer it. Karen Reed, I don't think would be forced to give a deposition before her criminal trial. So that's a great question. Freebird, I forgot what bit's called. Gotta Google, but our insurance covers us personally. So John O'Keefe's insurance would have to pay out, but non-Karen's prove that he was hit by a car and you're covered when walking. Yeah, that's called uninsured, underinsured motorist coverage. And that is the no fault, but not if you're a pedestrian. If you're a pedestrian, the person who hit you, their no fault covers you. That's the way it is in New York. So I don't know about Massachusetts, but funeral expenses would be caused by the perpetrator, who in this case, if it's true, would be a long crime is like doing something, would be Karen Reed's insurance company. So that is that. Yes, coffee. All right. Um, and here's Kim. I think I gotta go because they think something's happening in the Telus case. So come on over for that. I might just go live directly. Thank you. Hold on. What are they doing? Third Thunder Road Queen, thanks for the 10 says you're brilliant. How about a panel of you, Bettero, Lawyer No, and BC? That's how we beat Vinny. That's awesome. That would be fantastic. I don't know if Peter would come on. Who's BC? Thank you. All right. I don't know what's happening in Telus, but come on over for that. I'm going to have to set this up. So there we go. Yeah, they're going to have to prove it was a false narrative. So good luck to them. Make sure the bell is hit so that you know when I go live on Telus, because that, wait a minute. Let me just see if I can find something on here, because there's somebody who's in the courtroom, and let me find out if anything's happening. They just had some sound on there. So hang on. Yesterday, it says that the jury deliberated from 1:49 to 5:56. And this reporter is not saying anything more yet. So I don't know why. They just came on the record. Maybe there's another conference happening in that courtroom. Maybe that's what that was. Perhaps, perhaps. All right. Thank you, moderators, for keeping the chat classy today. And I really appreciate that. Oh, thank you. Thanks, Aunt BB. Nurse Kim's in the chat. Nurse Kim is in the chat. Hello, Nurse Kim. Thank you. Thank you. Thanks for keeping it classy. Guys, please hit the like button on the way out. It really helps the algorithm. And we'll come back and talk about this more as soon as we get an answer on this lawsuit. But let me know in the comments what you think. Come for me respectfully. It's my opinion, and I'm sticking to it. Thanks, mods. Love you guys. Love you, members. Love my cupcakes. Love everyone out there. And viewers, replay viewers, if you would be so kind as to just, hit the like button and help a girl out. And also, if you wouldn't mind subscribing, it is free. And also, that way I can meet my personal goal of beating Vinny Politan in subscribers, that he doesn't know anything about this contest. And I think I'm only like 4,000 or 5,000 subscribers behind Vinny Politan's personal channel on YouTube. And that would make me so happy. So thank you so much. As I always say, my friends, be cool, be kind, be classy. It really is not hard. It is so not hard. I promise you. Your life will be better for it. And I'll see you real soon, maybe like in 10 minutes on Telus. So see you soon.